This House is in session.
Announcements by His Honor the Speaker.
I'm in receipt of a letter from the Honourable Santia Bradshaw MP, Deputy Prime Minister. July 30th, 2025, His Honor Arthur E. Holder, SC MP, Speaker of the House of Assembly, Parliament Buildings, Trafalgar Street, Bridgetown. Your Honor, the House now stands adjourned until Tuesday, 12th August 2025 at 10 a.m. Pursuant to Standing Order number 6.9 of the Standing Orders of the Honourable House of Assembly, I hereby submit that the public interest requires that the House should meet on an earlier day than that to which the House stands adjourned in order to debate the Firearms Amendment Bill 2025, Criminal Proceedings Witness Anonymity Bill 2025, Police Amendment Bill 2025, Juries Bill 2025, and the Interception of Communication Bill 2025. Should you be satisfied that the public interest so requires, government requests that the House should be summoned to meet Friday, August 8th, 2025 at 10 a.m. Government proposes that the business of the House should be that mentioned above. Yours faithfully, Honourable Santia J. Bradshaw MP, Deputy Prime Minister and Leader of Government Business. I am satisfied, in accordance with Standing Order 6.9, that the public interest so requires.
Messages from Her Excellency the President. What?
You got one?
No.
No?
No.
So where read it?
So we got to do
Go right there. Oh. First reading bills.
My apologies. First reading of bills.
Honourable Leader of Government Business.
Mr. Speaker, I beg to move the first reading of the Juries Bill.
The question that the aforementioned bill be read here first time. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Orders of the day.
Honourable Leader of Government Business.
Mr. Speaker, I beg to move the suspension of Standing Orders 6, 16, 18, 20, 42, subsection 5, 43, and 44 for the remainder of the day's sitting.
The question is that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. The aforementioned standing orders are hereby suspended for the remainder of the day's sitting.
Government business.
Government business is the order of the day.
Mr. Speaker, order number 4, in the name of the Honourable Attorney General and Minister of Legal Affairs, to move the second reading of the Interception of Communications Bill 2025.
Honourable Member for St. Joseph.
Mr. Speaker, there are not a lot of occasions in the life of a parliament when it has to take a bold step of intentionally legislating in areas which are considered to be both sacred and also murky. Whenever a parliament has to take a step which would see the infringement to whatever degree of an individual's constitutional rights and freedoms, it is not only a momentous occasion, but it is something that can only be taken in the most, or after the most sober of consideration. We are here today to debate a number of bills, and therefore I wish to ask that we have a cognate debate of the bills which are set out in the relevant orders. Those bills, sir, are the Juries Act, Firearms Amendment Act, Interception of Communication Act, Criminal Proceedings Witness Anonymity Act, and also the Firearms, and also the Police Act. I think I mentioned the Firearms already. So we want to have a cognate debate on all of these matters, sir, in as much as they are all inextricably intertwined and all bear importance to the criminal justice system.
The question is that the aforementioned bills be debated in a cognate debate because they are inextricably linked. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it.
On this occasion, sir, we are going to be looking at a number of pieces of legislation, all of which touch and concern the matter of crime, criminal justice reform, law and order. They are of interest, perhaps, to various segments. Perhaps the Juries Act is of special interest to the judges. The Interception of Communication and Firearms would be, of course, of great interest to law enforcement, police, same thing. But at the heart, Mr. Speaker, they represent the results of a firm commitment to the people of Barbados by this government to ensure that the criminal justice system works effectively, and to ensure that there is a tough stance on crime. I've heard it said, Mr. Speaker, that this administration has been soft on crime. But when you look at the large number of pieces of legislation that we have brought to this Parliament in the area of criminal justice reform, from the time we came to government in 2018, it is clearly to be seen that this administration has bent over backwards to make sure that all of the legislative tools that are required for the arsenal of law enforcement have been made available. Mr. Speaker, we came to government, we amended the Firearms Act to provide for mandatory minimum sentencing. That is not the act of a government that is soft on crime. We provided legislation, sir, dealing with judge-alone trials in order to make the system more efficient. At this point, we've had 2 judge-alone trials. And there are many other pieces of legislation that we have brought to the table to strengthen the arm of law enforcement and to ensure that the judicial system is able to deal effectively with the matter of criminal justice. Criminal justice reform has been foremost in our mind. Today we come to bring 3 new pieces of legislation and 2 amendment bills, and I will come to them in turn. But with your permission, sir, we will just do a brief overview. Our Juries Act is old. It is cumbersome. It has some characteristics that have not allowed the justice system to work properly. So it was incumbent on us to make those changes. Our Police Act has to be brought into the modern period, and we're addressing that. The Firearms Act, the Amendment Act, is seeking to address areas of deficiency. Witness anonymity legislation is seeking to put a whole new face on the question of the protection of witnesses. And in many respects, so too is the Interception of Communication bill. That's why we're doing them all at the same time, sir. The Interception of Communication bill, Mr. Speaker, It's an uncomfortable subject to discuss. There's no doubt about it. It is uncomfortable because we all accept that there's a right to privacy. Interestingly enough, though, for constitutional theorists, that right to privacy really only received the blessing of our apex court in 2018 in a decision that I know you know well, sir, the decision of Nerve and the Queen. Up until that decision was given, the overwhelming legal opinion has been that there was no right to privacy. And that is a legal opinion that I proffered when it was last in the seat of AG. It is a legal opinion, sir, that was proffered by all of the attorneys general before me, that we had no right to privacy. But in the case of Nerve in 2018, the Caribbean Court of Justice construed Section 11 of the Constitution, which, as you will well remember, begins with the words, whereas. And whenever you see a section beginning with the words whereas, we always treat it as being a preamble. It is a lead up to that which is key, but is not itself capable of enforcing, of providing any rights. And that was the view that was held up until 2018. But in 2018, the Caribbean Court of Justice found in our own case, Nerve, that section was justiciable, that section conferred rights, and that section was therefore capable of being enforced in our courts. And what is in that section, sir? One of the things mentioned in that Section 11 is the right to the protection of privacy in your home. Now, the Act, our Constitution talks about in the home, but it is a fundamental principle of constitutional interpretation that the Constitution has to be given the broadest possible interpretation in order to see it achieve its goals. And therefore, the right to privacy is seen by the courts as being more than privacy in your home. It is right to privacy of your person and all that your person entails. That is the constitutional background. However, sir, this question of intersection of communication is one that has lurked in the shadows for decades. It is one that this Parliament has never addressed. It is one that law enforcement has spoken in hushed tones about. It is one that when you hear the word, you sort of shy away from it. But the days of shying away from it, Mr. Speaker, if not being over, must be brought to an end. These are the facts, sir, or this is the fact. Interception of communications has been a tool in the arsenal of law enforcement the world over from the day the first telegraph wire was strung between two poles in the United States. It came to be called wiretapping because that is what they did. They tapped wires into the existing communication network, which was at that point in time wired. In the 1920s, the US Congress passed its first legislation supporting the use of intersection of communications. And that perhaps set the ball rolling. I think the UK certainly had their legislation probably about 20 years ago. The fact is, Mr. Speaker, that interception of communication by the police service, by our law enforcement, has been a tool that they have used for decades, sir. I say we speak about it in hushed terms, but the fact is, it is a tool that they have used for decades. It is a tool that they've used, and when I say decades, I'm making the point that they've been using it over multiple administrations. And that cannot be denied. It is a tool that has been used by the police service, certainly when it was Attorney General on the last occasion, and since coming back to this August seat. I can say that on no occasion have I ever had the opportunity to engage with the police service on what investigative tools they use. I've never been told whose communications they've intercepted, nor have I ever asked, nor have I ever been given the opportunity to even make a suggestion. But the fact is that it has been done. And it was done on the basis that there was no right to privacy. But our apex court, having now said that there's a right to privacy, we have a problem. The question is, will law enforcement be permitted to continue to do interception of communications, or will it be abolished in Barbados? Now, Mr. Speaker, we have, I suppose, some strident voices in our communities who will rail against such things as interception of communications, but they still want the police service to provide the best service possible to the people of Barbados. They want the police to catch every criminal. They want them to interdict every act of wrongdoing, but they would find it abhorrent that the police use technology to be able to do so. I have come today to this Parliament to ask this Parliament, Mr. Speaker, to give its sanction to the use of interception of communications by the security services in Barbados. But it is not just a bald request, sir. It is a request that is built on a foundation of a legislative instrument that affords the widest possible protection to the private citizen in the circumstances, and we're going to come to that. But the point is, Mr. Speaker, that we cannot, on the one hand, be saying we want the police to reap tremendous success, but want to hamstring their efforts at investigating crime. The problem we have, Mr. Speaker, is that the criminal element has become very sophisticated. If the criminal element has become sophisticated, if the criminal element is using technology for its advantage, Mr. Speaker, we would be foolish. We would be foolish. We would be guilty of dereliction of duty, sir, if we did not ensure that the police service had at its disposal all of the tools that it needed in order to keep pace with and, in fact, outstrip the criminal element in terms of use of technology and so on. We can't have it both ways, sir. We can't have it both ways. We want to be safe in our beds and we want to be safe on our streets. But somehow, there are some of us who feel that we should hobble the police service. I am not in that person's corner. I am not in those people's corner, sir. I support the work of the police service 100%, and I support giving them all of the tools that they require. Now, of course, some will say about AG, but when you come and bring this kind of legislation, you are telling the criminals that you intend for the police service to intercept their communications. Mr. Speaker, the criminals already knew that. The criminals already knew that. And I know, sir, that your only interaction with your clients is on a case-by-case basis. But I think it is common knowledge that the criminal element uses all kinds of technological means in order to be able to escape detection. So the criminals already know and have known that interception of communication was going on. It's not new. They would have been foolish to think that it wasn't going on. But we are obligated, Mr. Speaker, to do all that we can to make sure that the police service is up to the task, and this is one of those methods. I am constrained, Mr. Speaker, by rules of confidentiality and rules of prudence. So I cannot go into detail. I cannot give the chamber the facts. But I can speak in very broad terms and say to this chamber and say to the country that there have been many occasions when the Barbados Police Service has been able to forestall some of the most dastardly plans to conduct criminal activity in this country. It is to my certain knowledge that they have been able to prevent executions. They have saved lives. They have saved lives, sir, because of the availability of this tool. But the point is, Mr. Speaker, that when once Nerve, the decision that said that the right to privacy is enforceable, we've had to make a decision. Do we allow this important tool to be used in the dark? Or do we allow this important tool to be used by the police service with the necessary constitutional protection, with the necessary statutory authority, and with the appropriate guardrails to protect the privacy of its citizens? That's what governance is about, sir. We could have buried our head in the sand and allowed things to go on as they were, but that is not appropriate for a modern Barbados, and it is not an appropriate stance for a government that is serious about what it is doing. Before we began to draft this legislation, Mr. Speaker, we started to consult. And that consultative process engaged a number of stakeholders, but perhaps the most important stakeholder has been the public of Barbados through its representatives on the National Council for Citizen Security. You know, Mr. Speaker, the leader of the opposition was offered the opportunity to sit on that council and to join in its deliberations. My understanding is that he had initially accepted, but then he refused. That is my understanding, and I'm happy to be wrong. That is my understanding, sir. Now, Mr. Speaker.
Honourable member for Christchurch South, you know much better than that. Honourable member for Christchurch South, you know much better than that. Turn on your mic, Honourable member.
I intend to sit here and to hear the entire speech. And on a point of order, I am rising to indicate to the chair that what the learned Attorney General said about acceptance of an offer to sit on a council or whatever it is called is entirely misleading. As the chair pleases.
Continue, Honourable member.
From the recent intervention,
Honourable member, please turn off your mic.
Sometimes you are known more by what you didn't say than what you did say. The honourable member said that he didn't accept. That's what he's trying to say. Implicit in that is that he was invited. History shows that he didn't sit on it. So implicit in that is that he refused the invitation. 1 and 1 is never 2.5, never 1 1/4. 1 and 1 is 2. You were invited. I remember was invited. He didn't sit on it. So he refused. Plain and simple. That committee, sir, was charged with the responsibility of doing a number of things. And one of the things that we wanted them to look at with some urgency was the matter of interception of communications. And it seized the opportunity, it appointed a subcommittee made up of a number of lawyers, one of whom used to be in Parliament for the other side, and who, until recently, was an officer of that party. I believe he was perhaps the first vice president. An executive officer. He, that individual, together with at least one other attorney, served on the committee. I don't believe he came as a proxy for the leader of the opposition. But the fact is that his political grounding was on that side of the fence. And that committee, sir, looked at the interception of communication legislation and came back to me as AG with certain recommendations, which we've taken on board. But the important thing, sir, is that they've said, we accept the need to have this kind of legislation in Barbados today. Now, that is an important thing, sir, because the National Council on Citizen Security is represented on by the church, by teachers, by labor, by a vast array of individuals, and they even included individuals who have been victims of crime and individuals who were involved in crime but have turned away from that life. The broadest possible spectrum of individuals. And they weighed in on it, gave us their recommendations, and gave this approach the thumbs up, sir. They gave this approach its support. So we don't come here today to bring a piece of legislation to the people of Barbados that has not been examined in its merits. In fact, Mr. Speaker, I am able to say to you that in the preparation of this bill, we tried to take the best from all of the jurisdictions in CARICOM. Mr. Speaker, we've had this kind of interception of communication legislation in Jamaica since 2002. We have it in Guyana. We have it in Trinidad. We have it in St. Lucia. We have it in St. Kitts. We have it in Grenada, sir. This kind of legislation is to be found across the Caribbean, both in our larger states and our smaller states, and from all of the evidence, all of the testimony that we get from those jurisdictions, it is an important and powerful tool in the arsenal of law enforcement. So, Mr. Speaker, Barbados is coming late to this dance. I tell you, Jamaica had it since 2002. This is 2025, and Barbados is now putting it on the table, sir. But more than that, we have a call for jurisdictions in the region to enact interception of communication legislation by none other than the Needles Point Declaration on Criminal Justice Reform, sir. You'll recall that in 2023, I think it was November, the Caribbean Court of Justice Education Academy held a major symposium in Barbados on criminal justice reform. And Mr. Speaker, one of the important things that came out of that conference is the declaration. It is the Needles Point Declaration, sir. And I don't know if the Needles Point Declaration is mere document of the House. It probably hasn't. And therefore, I seek leave to make it a document of the House, sir. And it is fit and proper that it should be, because this Needles Point Declaration, since having been adopted by participants of that conference in 2023, has been cited in the courts in the region no less than 60 times with approval. No less than 60 times with approval. So that tells you that as a document, as a foundation document for criminal justice reform, it has been received with wide acclaim in our courts. It has also been received with wide acclaim by the heads of government, because they, in their conference, have adopted the Needles Point Declaration. And this is what the Needles Point Declaration says, sir, at item 6. That laws be enacted to provide for greater use of forensic, scientific, digital, and expert witness evidence, including the use of modern evidence gathering techniques such as interception of communications. All right? So this is the Needles Point Declaration. Needles Point because it was made in Barbados, comes out of the CCJ, Caribbean Court of Justice, cited in no less than 60 decisions in our courts, approved and adopted by all of the heads of governments in their conference, and it says, including the use of modern evidence gathering techniques such as interception of communication, sir. So what we are doing today also has the solemn imprimatur of all of these august bodies, the CCJ, the heads of government sitting in conference. It has the imprimatur, sir, of the finest legal minds in the region. So we cannot afford to be timid about introducing legislation of this sort, especially when it is given the widest possible support in this important document, the Needles Point Declaration. So we come to this Parliament today acknowledging that this legislation will, no doubt, have the impact of infringing the constitutional rights of some individuals, but we come to this Parliament with the full understanding of what we have to do, and we're able to draw on the support that is given from these other ratings and other fora. I'm going to get to the bill very soon, sir, but I want to make the point about the infringement of the rights. Our Constitution has always made it clear that as sacrosanct as the rights contained in our Bill of Rights part, our Bill of Rights provisions, sir, as sacrosanct as those rights are, those rights must always give way to the greater good. I'm just paraphrasing the provision, but it is clear that the makers of our Constitution understood that at some point in time, in some degree, an individual's constitutional rights may be infringed, may be interfered with, but that infringement is permissible so long as it is in support or in pursuit of the greater good of the state. And that is not just a Barbadian provision, that is accepted as being a universal position, sir. The rights of the few cannot trump the rights of the many. So the right of the few who would find themselves subject to a warrant issued under this bill is acknowledged, but it must be subjugated to the right of a government, to the right of law enforcement to protect the state and its citizens, its residents, its visitors from harm. That is all it is. It is a simple an equation of that sort. You have your fundamental human right to privacy, and we understand it. That is why we pick up our phones and talk so freely. That's why we're able to communicate freely, express our ideas freely, express even our disagreement with ideas freely. But the right of a few who seek to tear down this society, who seek to perpetuate criminal activity, who seek to survive on the backs of people by committing hideous acts of wrongdoing. The rights of those few, sir, must always be subjugated to the rights of the many. So that is the context, Mr. Speaker. That's the context, that's the constitutional context. But there's also a very practical matter. And that practical matter has to do with the fact that increasingly, when you're dealing with sophisticated criminals, you have to use modern evidence gathering techniques. We just talked about that. But you know what's worrisome, Mr. Speaker? The fact that more and more we are finding individuals who are unwilling to come forward and give evidence because they are fearful for their safety, they're fearful for their lives, they're fearful for the lives of their loved ones. We see it all the time. It's funny, sir, that the average Barbadian, well, I shouldn't say the average Barbadian. It's funny, sir, that many Barbadians would gladly pick up a phone and videotape a whole fight, but ask them to come court and say that they see a fight, and let me come in the way. Will not come. We have situations in Barbados, Mr. Speaker, where witnesses have been intimidated by accused persons in all kinds of ways. So in an environment, Mr. Speaker, where witnesses are fearful of coming forward, where there's a risk of intimidation, it becomes important for the state to rely on other than usual methods of gathering evidence. Plain and simple. When a prosecutor in a courtroom is able to play a conversation where certain things are said by an accused person, that evidence is virtually uncontrovertible. But on the other hand, to ask a witness to come forward and say, you have a problem. One is virtually uncontrovertible, the other one you really can't be sure about. And then, even if you're sure about it, there's always the risk of witness intimidation. That is where we find ourselves, Mr. Speaker. So let's talk a little bit about this legislation. As I said, we've had the benefit of being able to draw on the experience of our sister territories. We've looked at all of the equivalent pieces of legislation in the region. I forgot to mention that the Bahamas has also had it for the last 15 years. So we had the benefit of being able to look at how all of these countries, Jamaica, Bahamas, Trinidad, St. Lucia, Grenada, Guyana, St. Kitts, how all of them have approached the matter of intersectional wireless communication. And the first thing is that they all begin with the standpoint that because we are infringing the Constitution, because we're infringing an individual's constitutional rights, this law must be enacted in accordance with Section 49 of the Constitution. Section 49 says, in essence, that if you are either going to amend or impliedly amend the Constitution, you have not only to pass it by a supermajority of 2/3, but you have to say in the bill itself that this is your intention. So we're covering off that basis first, and when you look at the legislation, sir, it opens up after it describes the act by saying enacted by the Parliament of Barbados in accordance with the provisions of Section 49 of the Constitution. If it did not say that, sir, it will be treated as an ordinary law And we know from a long line of cases, perhaps most recently being the Trevor Brown against the superintendent of prisons. That's a decision of about 2 or 3 years ago. You cannot amend the Constitution by just using an ordinary law. So we've covered off that base. Now, Mr. Speaker, we've tried to use language that is normative and technology neutral. Throughout this presentation, that is, you'll probably hear people referring to wiretapping, but that is an anachronism. Nobody taps wires into other wires anymore. It's just something that is a common reference and will probably be used by individuals, but intercept is described in the Act in fairly normative and technology neutral terms as being, it means listening to, monitoring, viewing, reading, or recording by any means such a communication is passage over a telecommunications network without the knowledge of the person making or receiving the communication. So it is the interception of a communication without the knowledge of the person making or receiving the communication. So it is being done in secret. The subject of the interception is not to know that this is what is happening. And it is because of this reason that the application to the judge, we'll come to that later, the application to the judge is done ex parte. And for those who are not so familiar with the concept, when you make an application ex parte, it simply means that the other side, interested parties, will not be notified, which is common sense because the interested party will be the person who you're trying to whose conversations you're trying to monitor, whose email, whose whatever it is you're trying to monitor. And therefore, you can't tell them, you can't say, we are going to apply to the court to monitor your communications, and you are free to come court tomorrow morning to raise any objection that you might have. These applications, Mr. Speaker, are made to the Chief Justice or to such other judge as the Chief Justice may appoint. Now, Mr. Speaker, somebody tried to float a kite earlier in this discussion, not today, but early in the discussion, general discussion in the section of communications, to talk about a justice of the peace authorizing interception of communications. Now, it's difficult to speak kindly of that kind of comment because it means that the individual is so ill-informed that they spew whatever comes to mind. It is true, Mr. Speaker, that the permission to carry out an interception is a warrant. It is true that search warrants, of which this is a kind, are generally issued under the signature of a justice of the peace. But not so in this case, Mr. Speaker. Nobody is able to run to justice of the peace and say, sign this and sign that and let me go and do this. The only individual who can authorize the interception of communication is the Chief Justice of Barbados, or if he's not available, such other judge as he would assign. So you have to literally go to the highest authority. Under this act, there is no minister who can authorize interception of communications. There's no junior functionary who can authorize interception of communications. Only the Chief Justice or such other judge as he assigns is able to authorize the interception of a communication. If an interception of a communication occurs without that, that is unlawful, and the person who is guilty of unlawful interception can find himself liable to a term of imprisonment of 7 years or to $500,000 in fine, even if that individual is a police. So the bottom line is this. It is against the law to intercept communications. The only exception to that rule is if the Commissioner of Police or the Director General seeks and obtains a warrant from the Chief Justice or such of the judge as he might assign. The point is this, sir, that the decision to issue a warrant is taken only by the highest judicial authority. And even then, the Act sets out what that judge can take into account. So let me take you to that place, sir. Section 7, well, we say clause 7 of this bill talks about the warrant itself. And it says an authorized officer. Now, let me repeat, sir. An authorized officer is not Station Sergeant Brown. It is not Assistant Superintendent Jonathan. It is not Assistant Commissioner of Police or Deputy Commissioner of Police Cox, whoever they may be. An authorized officer is defined in this bill as meaning the Commissioner of Police or the Director General of the Anti-Corruption and Anti-Terrorism Agency. So the application is made by them in their names. And therefore, before the application can be made by them and in their names, they themselves have to be satisfied that all of the fundamentals, all of the requirements are in order before they can go to the court. So there's no constable who can go and apply for a search warrant. There's a station sergeant. There's no inspector of police. There's nobody who can go and apply for a search for this kind of warrant except the Commissioner of Police or the Director General of the Anti-Corruption and Anti-Terrorism Unit. That in itself, sir, is an important safeguard because that does not exist in relation to search warrants of the ordinary kind. So clause 7 says, an authorized officer may apply ex parte, we talked about that earlier, to a judge, and we've explained that a judge is defined as meaning the Chief Justice or such judge as he might assign, for a warrant authorizing the person named in the warrant, A, to intercept such communications as are described in the warrant. Let me repeat, to intercept such communications as are described in the warrant. So you must say in the warrant specifically what kinds of communication or communications you are looking to intercept. You can't just come and say, I want to intercept communications generally. You have to tell the judge specifically what kind of communications you're looking to intercept. You must also disclose the intercepted communications or the warrant to such persons and in such manner as may be specified in the warrant. That really speaks to being able to tell the telecommunications provider, I have a warrant, and that's also dealt with later on. Now this is key, sir. Clause 7.2. A judge shall not issue a warrant under this section unless he is satisfied. So these are the prerequisites that must be met before he can issue a warrant. Unless he is satisfied that the warrant is necessary, 1, in the interest of national security. I don't even think that needs an explanation, but the point is, in matters related to national security, the security of the heart and soul of the state, if a warrant is necessary in the interest of national security, then the judge can grant it. Or, if it is necessary for the prevention or detection of any offense settled in the first schedule, where there are reasonable grounds for believing that such an offense has been, is being, or is about to be committed. Mr. Speaker, what are the offenses in the first schedule? Well, let me tell you. They are the most serious criminal offenses available. The most serious criminal offenses under our law: murder, treason, terrorism, trafficking in persons, kidnapping or abduction, money laundering, a variety of offenses under the Drug Abuse Act, things like producing, manufacturing, transporting, importing, and so on. Importing, exportation, or transshipment of any firearm or ammunition in contravention of the Firearms Act. Manufacture of or dealing in firearms or ammunition in contravention of the Firearms Act. Illegal possession of a published weapon or any other firearm or ammunition in contravention of the Firearms Act. Any offense contrary to the Prevention of Corruption Act, arson, and then there's the sweep-up clauses. Any offense for which the penalty on conviction is imprisonment for 10 years or more, and the act of aiding and abetting or conspiring to commit any of the offenses that I've just referred to. So this sets out it is a broad list, but you can see that it deals with the most serious kind of offenses under our law. So you can only get a search warrant for the interception of communications. You can only get a warrant for the interception of communications if you are either investigating an offense that has happened of this kind, or if you are looking to prevent an offense of this kind from happening. So those are the things that the judge must consider. You must also satisfy the judge that the information that you hope to garner is likely to assist in the investigations concerning any of these matters. But then you must go further, and you must be able to demonstrate to the judge that other procedures, other investigative techniques have not been or are unlikely to yield any results. So you can't just go and say, this person we suspect of murder, or we believe he's looking to commit murder, we want to do a wiretapping, we want to intercept his communications. You must satisfy the judge that other investigative procedures have not been or are unlikely to be successful, or that they will be too dangerous to adopt in these circumstances, or having regard to the urgency of the case are impracticable. You must also satisfy the judge that it will be in the best interest of the administration of justice to issue the warrant. And you must also satisfy the judge that the interception of the communication must be proportionate to what is sought to be achieved. So there has to be a level of proportionality between what you want to do and what you hope to achieve. If those two things are disproportionate, then the judge cannot make the order. An application for a warrant under this section shall be subject to section 19. It must be in writing and accompanied by an affidavit deposing to the following matters: the name of the authorized officer and the entity on behalf of which the application is made. It must also include the facts or allegations giving rise to the application. Sufficient information must be given to the judge to allow him to issue the warrant. It must also indicate the period for which the warrant is required. Mr. Speaker, the police will have to jump through a significant amount of hoops in order to be able to satisfy a judge that a warrant is warranted. He has to do that. So if the judge is not satisfied that it is appropriate to issue a warrant for interception of communications in any of these cases, then it will not be granted. Now, Mr. Speaker, you may ask yourself, well, why are we doing this? On the one hand, you say you want to give the police the tools, but on the other hand, you're making them jump through so many hoops and contortions that it makes it difficult for them to use the tools. Mr. Speaker, one of the fundamentals of governance is always this, that you achieve the ends of proper governance by methods that result in a minimum of friction and a minimum of waste. That is the balancing act that we engage in every day. It is a question of proportionality. It is a question of, have we done enough to protect the unsuspecting citizen? No matter how wrong a person might be, no matter how guilty a person is, Mr. Speaker, in our eyes, we still guarantee him the right to a fair trial. No matter how hideous a person's criminal act is, we still say you're entitled to have a lawyer of your choice. We do not set about stripping away all of your rights to justice and fair play because we do not approve of your conduct, sir. In fact, it is precisely because we don't approve of your conduct that we eliminate any chance of bias by making sure that those hoops are put in place. They're not impossible requirements, Mr. Speaker, but we're trying to say to the citizen, we understand the intrusive nature of what this is, but we have to give you certain guarantees. We have to guarantee you that only people who have a role in criminal activity can have their conversations liable to be intercepted. That's the first thing that this act says. Because you must tell the judge what is the crime that you are either detecting or looking to prevent. So unless the judge is satisfied that the individual whose communication you want to intercept is a part of a criminal activity, then he's powerless to authorize it. So then people sit in earshot today and wonder, well, so does this mean that they can come and intercept my communication? The answer, sir, is no. The answer is no, because unless you fall within the four corners of this act, you don't have a thing to worry about. So let me reiterate, for all of the many, many, many thousands of Barbadians, the many tens of thousands and hundreds of thousands of Barbadians who are law-abiding, they have no need to fear this bill simply because this bill only allows for the interception of communications in an instance where an individual is involved in the criminal activity that we've outlined in the schedule. Plain and simple. So the Barbadian who is law-abiding has nothing to fear. Because under no circumstances will the Chief Justice be able to say, I've given them a warrant to intercept your communications. But let's look at it this way, because we can't speak and ignore some realities. Because a person is a criminal don't mean he ain't got a mother who loves him, a sister, a brother, a girlfriend, a child. And those individuals who are in his circle, his friends, may have nothing at all to do with criminal activity. When a warrant for the interception of communication is issued against John Mortimer Brown, John Mortimer Brown may have in his circle of friends the jet ski man from Bay Street. He may have in his circle of friends the pastor from the church in Chapel Gap. He will probably have a relationship with a lawyer. He may have to call the clinic or his doctor. It is in every conversation or every communication that will constitute evidence in a criminal case. So what does the law say? The law says that those kinds of communications that are either privileged or that are irrelevant for the purposes that the warrant was obtained have to be destroyed. They have to be destroyed. So criminal A calling the school to save their school today, nothing at all to do with this case, has to be destroyed. Criminal A is calling his brother to see if he could pass and pick up something from the supermarket for their mother, nothing at all to do with the criminal investigation, it must be destroyed. When his Darren called him to ask him if he could pass and bring something, again, it is a conversation. The conversation includes him, the criminal person at the end, but because its content has nothing to do with what is being investigated, that too has to be destroyed. So, I am seeking to answer the question, when you intercept a person's conversation, are you not only going to be intercepting conversations that are innocent by nature? That are innocent by nature? The answer is yes. But the law provides a mechanism which says those things have no place in the custody of the police, in the custody of the anti-corruption agency, and they are required to be destroyed. Mr. Speaker, the warrant is going to be valid for 120 days. That is dealt with at clause 9. A judge may renew the warrant for such other period as he can specify, stipulate, decide on, but it must not exceed 120 days from the end of the first warrant. So, 120 days, roughly 4 months, the warrant will expire. But the judge can extend it by up to another 4 months, up to another 120 days. Now, Mr. Speaker, I know that these time periods may seem long, but let us accept that life is not a 50-minute episode of Criminal Minds. Life is not a 50-minute episode of NCSI or any of those pictures on TV where the crime happens and between 8 advertisements every few minutes and by 8 o'clock, the victim convicted and sometimes even charged, had a trial and lockup if you're watching Law and Order. Criminal investigations are painstaking. They're painstaking, sir. And they take time and effort. And it is therefore important that the warrant be given for sufficient time as to allow the officers who actually do the interception of communications to garner the information that they need. And if nothing is found in that time, it can be extended further. Beyond that, though, Mr. Speaker, it cannot be extended. Beyond that, sir, you would have to come for a new warrant. The judge can only extend it if exceptional circumstances exist. So you can't just come and say, man, we didn't find nothing yet. It doesn't work that way. You have to satisfy the judge that exceptional circumstances exist, which would allow him to extend that time. I've indicated, Mr. Speaker, that a lot of information has to be given to a judge. An application has to be ex parte, it has to be in writing. But there are always going to be circumstances, Mr. Speaker, when an application has to be made as a matter of urgency. You and all the judges in this chamber will be familiar with the powers of a judge on an application for an injunction to dispense with written applications. And we know that judges have granted injunctions on the basis of a telephone call or on the basis of a letter written. But in every instance, an undertaking is given to file the documents within the time that the judge may stipulate. This statute contemplates similar things. It contemplates that something might be urgent, and you need to be able to get a wiretapping and interception done immediately, and therefore you don't have the time to do all of the paperwork. But this act says you can get it, the judge can give you the warrant for interception, but that you must then file those documents within 72 hours. And this is only where it is urgent, and if you don't file the documents, then the judge can revoke the warrant. I've mentioned revocation, Mr. Speaker. A judge is able to revoke the warrant for a variety of reasons if he fails to submit a report. These are found at clause 12. If the judge is satisfied that the objectives of the warrant have been achieved, if the judge is satisfied that the grounds on which the interception warrant was issued have ceased to exist, or if conditions have changed in a particular way that it would not be possible anymore. So it is possible for the judge to revoke the warrant in certain circumstances. The Commissioner of Police has a responsibility for making sure that progress reports are filed, sir. So you don't just get a warrant and go on with your business. Progress reports have to be filed either at the end of the warrant, or if the judge requires it, during the exercise of the powers under the warrant. So this act provides that a judge may at any time require the authorized officer on whose behalf the relevant application was made to report to him in writing on the progress that has been made towards achieving the objectives of the interception warrant and on any other matter which the judge considers necessary. What is important to note from this, Mr. Speaker, is that we are providing in the statute for monitoring obligations. Remember I said to you, Mr. Speaker, at the outset that this has been going on for decades. But there was no monitoring. There was no permission to be sought. There were no requirements that had to be met. Now, when we employ this tactical measure, interception of communications, you have a duty to report to the judge on what progress you've made and what is going on with the carrying out of the search of the warrant. And when it is completed, sir, you have to submit a final report to the judge. So in every instance where this kind of warrant is issued, you have to submit a report to the judge. When that report is submitted, it is also submitted to an independent monitoring commission, independent monitoring authority. Now, Mr. Speaker, let me say a little bit about this authority. Mr. Speaker, one of the features of the legislation across the region is the need to monitor the use of these warrants from start to finish to make sure that they're done in accordance with the law. We've gone from a situation where, and I don't mean any disrespect to members of the police service who have and continue to serve us well, but there were no guardrails. There was no boy to say, stop. There was no boy to say, hold on a minute. There was no boy to say, pull back. You're going too far. In this act, we're saying that the judge has the authority to do all of those things. The judge. But in addition to the judge, because Barbados is still a small society, there may be biases. So in addition to the judge, sir, we have established an independent monitoring authority. And that independent monitoring authority is to be made up of 3 individuals, sir. And these 3 individuals are going to be appointed by the minister, of course, after the approval of cabinet. Now, Mr. Speaker, the bill that is here, and I'm going to have to make a brief amendment to it, so let me just flag it now. The intention is that the members of the commission is to be made up of a retired judge, a member of the civil society, and another person in the discretion of the minister. This is in the second schedule, sir. But we don't want to compel the appointment of the individuals on this independent monitoring authority to be from amongst Barbadians. As I said, sir, we have a small population. So we've determined that it is in the best interest of transparency, justice, and due process that the entire membership of the CARICOM community will be there for us to draw on when we appoint this independent commission. Now, it doesn't mean that we have to, but it does give us the flexibility, and the amendment is to be made to ensure that that happens. It does give us the flexibility, Mr. Speaker, to be able to say, look, this matter is one that people feel so sensitive about that we want to have a retired judge from Jamaica, a member of civil society from Trinidad, and some other eminent person from St. Lucia. So that we have the opportunity to bring in 3 people, none of whom may have any connection to Barbados beyond coming from a sister island, but they will come in so free of taint, so free of bias, that they will be more amenable to saying, stop. This was done wrong. You have to withdraw this. That information has to be destroyed. And we feel, Mr. Speaker, that by opening up the membership of this commission to individuals who are beyond our shore, either one of them or two of them, or even all three of them, Mr. Speaker, that we will bring to the system a level of, shall we say, a level of independence that we may not have, if we drew from amongst the people in Barbados. Now, as I'm saying, we have the option of doing so if we wish, but we also have the option of going outside of Barbados and going to other eminent persons within CARICOM to constitute this monitoring committee. Mr. Speaker, the bill talks about the powers of the monitoring committee. I have said earlier that the monitoring authority will receive the final report or receive any reports that are made to the judge. But it also has the power of its own motion, Mr. Speaker, of its own motion, to look into particular instances where this kind of warrant has been issued. And it can carry out any investigation, this is found at clause 26, that it considers necessary or desirable in connection with the interception of communications to ensure that such interception is conducted in accordance with this act. Now, Mr. Speaker, it is not for the authority to determine what evidence is to go before the court, but it is open to the authority to order the destruction of things that, of information that should not have been gathered. It has the ability to stop the activity which contravenes the act and so on. So the monitoring authority has a supervisory role. It has no part in issuing any warrant, but once a warrant has been issued, the monitoring authority has the power, either of its own motion or as a result of information that comes to it in the course of any of the reports, to investigate any or all grants of warrants to ensure that they're granted, that the powers under the warrant are exercised in accordance with the law. Let me say one final word on this bill, and it has to do with admissibility of evidence. Mr. Speaker, you would know that at common law, a judge has always had the power to exclude evidence where it was in the interest of justice to do so. And you know of instances where it has happened, sir, where it is more prejudicial than probative, where the evidence, it happens sometimes when confessions are impugned. And you say, we do not believe that this confession was a genuine confession, so it has to be struck out. But there's also the power of a court to refuse to admit evidence where the circumstances in which the evidence is garnered, is gathered, is collected, is abhorrent to principles of justice. So it would have been open to an individual whose evidence was obtained through the interception of communication to say to the court, this was obtained in breach of my rights and it should not be admitted. And that is one of the things that would allow a court to refuse to admit it. But because we are regulating all of this, because we're putting this on a firm footing, we are making it clear, sir, that any evidence which is obtained by interception permitted by warrant is admissible as evidence in a criminal proceeding. So the matter of infringement of constitutional rights does not arise in this instance, where the issue is just interception of communication. As long as the evidence is garnered in this means, it is admissible. But it is also, policy-wise, a sensible approach to take, because when you are able to intercept a communication, you are getting the voice, whether in writing or orally, you are getting the voice of the individual saying whatever the evidence is. And that is the best evidence that you can want. Mr. Speaker, I have taken the trouble of going through the provisions of this act, because I think it is important that the Chamber reads into record what this act is about, Mr. Speaker. Currently, the CCJ is doing a case on appeal from Barbados, and they have asked to see the Hansard. And as you well know, sir, the Hansard is an important aid to interpreting and applying statutory law. So it is important for us to establish what we want to achieve and what is intended, so that in the event that this legislation that an individual seeks to impugn this legislation, it will be the debate itself and what we anticipate will come from this legislation will be important as an aid to statutory interpretation. Mr. Speaker, I am satisfied, in fact, I'm more than satisfied, that we've included in this bill sufficient provisions to protect every individual. The individuals who are law-abiding, who are not involved in anything, they have nothing to fear because no warrant can be issued against them. None, simply cannot be. And that's what the Act says. The Act says, in order to get a warrant, you must be able to show me all these things. If you can't show it, then you can't get the warrant. So that is to protect the vast, vast majority of Barbadians. But even then, we protect the individual, because an individual is always innocent until they're proven guilty. Those are the things that we hold dear, sir. And we therefore still have to provide. As I said earlier, just because we may not approve of what you do doesn't mean that we strip you of the protection of the law. And therefore, it has been important to stipulate that a warrant of interception can only be issued in particular circumstances. Mr. Speaker, I've said that this is a cognate debate. I believe that I've spoken about this particular measure enough. As I said, it has received the blessing of the National Council for Citizen Security. It has also received the concept or the recommendation for enacting legislation such as this comes from the Needham's Point Declaration, so it has the imprimatur as well, and is being seen as an important part of criminal justice reform, because the better the evidence, the fairer the judicial process. And this allows us to get evidence that is firsthand and largely incontrovertible. Mr. Speaker, let me speak very briefly on the other piece of legislation. The criminal proceedings witness anonymity bill. Perhaps talking about this legislation, interception of communication, and speaking about the difficulty of having witnesses come forward is a good segue into this next piece of legislation. Criminal proceedings witness anonymity bill. Let me say at the outset, Mr. Speaker, that we have a practice direction issued by former Chief Justice. I crave your indulgence if I mention his name, but this is only to set the timeline. Practice direction signed by former Chief Justice Sir Marston Gibson. And that practice direction deals with protection of witnesses. Over and above that practice direction, sir, the common law has always given the judge the power to put measures in place to protect a witness. And this is predicated on a simple thing. If a witness is not protected, if a witness cannot come and give his evidence without taint, without bias, without fear of recriminations, then the criminal justice system will not function. And so at common law, judges have always been able to put things in place to protect witnesses who are under threat. Our practice direction issued by Sir Marston, former Chief Justice, was a step in terms of codifying what those arrangements would be, so that it's not left up to judges to arbitrarily decide what they will and will not do. But we feel it's important, Mr. Speaker, that we put this matter on a statutory basis. And this is because, Mr. Speaker, another fundamental right of an accused person is to face his accuser. That is a basic premise on which our criminal justice stands. In fact, it is a premise on which all of our law stands, because the same thing obtains in civil law. You must be able to face your accuser, and if you choose, you must be able to cross-examine him or her to weaken their evidence or to show that they're lying. Witness anonymity legislation, by definition, Mr. Speaker, by definition, will allow a witness in a case to be incapable of being identified. Now, this happens in two ways, Mr. Speaker. There's a famous case out of St. Vincent where two men committed a murder. While in prison, one of the men spoke with somebody in prison and said, this is what went down, this is what we did, and so on. That person wanted to give evidence in the case, but for fear of being murdered himself, he had to seek the protection of the St. Vincent and the Grenadines witness anonymity legislation. And so that individual was able to freely participate in the hearing of a case and dispensation of justice for the benefit of the community and society as a whole. Because it would not be right that an individual should escape justice, should escape being found guilty simply because the witness is afraid. The witness in that St. Vincent and the Grenadines case was able to benefit from certain technical things which made it impossible for the accused person to identify him. Now, Mr. Speaker, as I said, we're looking to put this on a statutory regime. It applies to both magistrates and high courts. So it's not a case where we're only talking about high court stuff. Witness anonymity can be important, even in the lowest cases. And therefore, this ability to protect the witness is going to be available in both the magistrates and the high courts. Once again, Mr. Speaker, we have gone the consultative route. This legislation has been shared with the Criminal Justice Reform Committee, chaired by the Honourable Chief Justice. That committee is constitutive of the AG, Minister of Home Affairs, the DPP, members of the bench, members of probation, the superintendent of the prisons, the private bar, a wide cross-section of individuals, all of whom have a role to play in the reform of the criminal justice system. So that committee has looked at the legislation. It was also sent to the bar for their comment, and I want to thank the bar at this time for being so important a partner, because it isn't everything that we want to do they will agree with, and it isn't everything that they want us to do that we will agree with. But the point is, Mr. Speaker, is that we try to meet somewhere in the middle. We try to find common ground where possible. It is our role to govern, and we will not shy away from that, but we govern mindful of the views of the others. So the bar has certainly had the chance to review this legislation and has made some important comments on it, some of which we've been able to take into account. Mr. Speaker, I don't want, the bill is fairly straightforward. The kinds of measures that can be taken include such things as admitting a video recording of the interview of the witness. Now, Mr. Speaker, there are times when, and that's why we are recording more and more interviews. You've been involved in cases where the interview of the witnesses is perhaps better than the witness on the witness stand. It's an important asset in the arsenal of seeking justice, really, whether it is for the prosecution or for the defense. But it is also especially important in cases such as sexual offenses, assaults on minors, things of that sort, where the child may be so intimidated that sometimes even the adult, that they just can't come to court and give evidence. They're just not able to. They are so fearful sitting in court across from the accused person. They buckle, or the family member may know who it is. In those circumstances, sir, and again, these are things that happen. We're not trying to reinvent the wheel here. We're not trying to invent the wheel here, because other jurisdictions have this kind of legislation as well. I mentioned St. Vincent, for example, and we've tried to follow St. Vincent because it's a good example of it. So you can have a video recording of the interview of the witness used as his evidence in chief. So in other words, the person, when they first came into the station to make the complaint, may make one recording, may make multiple recordings over time. But as opposed to having the prosecution come and try to make them repeat everything they've already said, you can play the video recording as evidence in chief. The examination of the witness may be conducted through an intermediary approved by the court. This happens in our courts, especially with people who are unable to speak. So it already happens in a matter of speaking, but that's not witness protection, that's witness facilitation. But there may be circumstances in which it is important to protect the witness by having the evidence given through an intermediary. The evidence can be given by means of technology such as live link, so that the person is present in the court only virtually, and the parties to the proceedings will be able to hear, examine and cross-examine the witness. And again, a witness may be outside of Barbados. So they may be outside of Barbados because, again, they're fearful. In an extreme case, you're also able to exclude the defendant from court. That's not something I know that would sit well with most people, but the point is, in an exceptional case, that is something that is available. During the course of the trial, the court is able to prevent the use of names, addresses, contact details, or other identifying measures to make sure that the witness is not identified. Another common feature, sir, is the question of voice modulation, so that the individual may be in court, but behind a screen, but the voice is electronically altered, so the evidence is given, but you really can't identify who they are. These measures are cost-effective, sir, and can effectively screen the witness and his or her identity from the accused person. Again, we are late to the dance with this, but the time has come, Mr. Speaker, when in circumstances where we have an increasing amount of gang-related activity, instances of intimidation of witnesses are growing, it is important for us to be able to effectively protect witnesses through this particular mechanism. Mr. Speaker, the other thing that I would want to bring to this chamber is the Firearms Act, sir. The Firearms Act is being amended in two ways. The Firearms Act was amended by us back in 2021 to provide, Mr. Speaker, for mandatory minimum sentences. The one thing that we did not do on that occasion, though, was to expand the definition of firearms to include component parts. Now, these things may seem largely artificial, but it is, just trying to find the document, sir. Just bear with me, please. It is recognized, Mr. Speaker, that individuals can have component parts of weapons, but not be capable of being tried. So there was a case in Barbados where an individual had 4 firearms, Mr. Speaker, and he had 11 magazines. But the 11 magazines can fit none of the firearms that he had. So it was obvious, Mr. Speaker, that the magazines were not intended, some of the firearms were not intended to be, some of the magazines were not intended to be used in the firearms that he had. He had 11 magazines. But he could only be charged, Mr. Speaker, for the 4 firearms that he had. He couldn't be charged for having the magazines because there was no offense under our Firearms Act that related to that. So it was important for us to fill this lacuna by providing, Mr. Speaker, that component parts of firearms are capable possession is capable of constituting an offense. Equally, sir, we also know that firearms are frequently broken down, or maybe the word is stripped down, I'm not sure, but they're broken down and shipped into this country in parts. They're shipped in engines, they're shipped in all kinds of interesting ways, but they tend to ship them in ways that will occlude from the various scanners exactly what they are. Now, when they come in parts under our Firearms Act, you can't charge them. So this allows us, Mr. Speaker, to be able to charge individuals who possess component parts of a firearm, and we think it is an important lacuna to fill. The other matter has to do with the minimum sentences. Mr. Speaker, when we came to Parliament in 2021 to increase the minimum sentences for firearms, it was an important initiative. At that time, we were seeing an increasing number of firearm activity. We were seeing an increasing number of homicides caused by firearms. And that amendment, and let me remind the chamber, said that for a first offense, you would get a minimum sentence of 10 years and a maximum of 20 years. On a second offense, you could get 20 years as a minimum sentence and life imprisonment as a maximum sentence. The challenge, though, Mr. Speaker, as you well know, is that judges guard very jealously their jurisdiction to sentence. And that's already been covered in law. There's no Constitutional Law 101. When Parliament stipulates mandatory sentences, they are usurping the power of the judge and therefore breaching the rule against separation of powers. So the method that has been employed is to say these are the minimum sentences, but the court may deviate from these minimum sentences in certain circumstances. One of those circumstances that we provided for is that the individual is 18 years old or under. That is understandable. An individual who is under 18 years old, your heart goes out to them. You want to give them a break. You don't want to sentence that person to 10 to 20 years, give the person 20 years imprisonment just so. So that is an exception that we have no reservation about. But the second exception is if the individual has if this is his first conviction. Mr. Speaker, you have been in the trenches of criminal law for a long time. It is unfortunate, but the delays in our criminal justice system have allowed individuals to rack up what they call rap sheets that are half a mile long. Enough offenses. But given that the trials didn't take place yet, no convictions. So if you have no convictions, if you get charged with a firearm offense and are convicted, it is a first offense. It is a first offense because you have no conviction on any of the murders, any of the other robberies, the rapes. You have no conviction on anything else, remembering that you're innocent until you're proven guilty. So it is a first offense. So a court is therefore able to say, man, this is your first offense, and therefore we can reduce it down to 2 years or give you a fine or something like that. In fact, it regrettably is all too common now to give some of these first offenders fines. What we are seeking to do is to say, no. We're removing this exception from the law. Whether it is a first offense or not, this is the minimum sentence. There has been an important Court of Appeal decision coming out of Bermuda, which Bermuda does not have this particular exception, so the Bermuda courts are very strict when it comes to sentencing, and the Bermuda Court of Appeal, following Privy Council decisions, have upheld that particular approach. So I'm satisfied, I'm confident in the law, so that even removing this particular exception, where it is a person's first offense, will not offend any constitutionality or any separation of powers. There was also a provision which allowed for you to also veer away from the minimum sentence if it is in the, if public safety and public order will not be prejudiced. We consider that to be OTOs and necessary, so we're moving that as well. So that is the Firearms Act. I think that these are important measures that make the Firearms Act, again, to show that we are not making sport, sir, to use that language. We are not making any sport. This is evidence of a government that is serious about rooting out crime. The other piece of legislation, Mr. Speaker, is the Juries Act. Our Juries Act was enacted in 1970. It's been amended several times. What we are looking to do is to bring an updated piece of legislation which will govern jury selection, jury service, and the procedures and so on. The history of jury trials goes back, sir, to 1066 when the Normans conquered England. And the right to that, sir, was found in the Magna Carta. Mr. Speaker, it has served us well, but as I said, it is anachronistic. Since 2021, there have been 68,273 persons on the roll of eligible jurors. Now, I know the average Barbadian would be thinking, well, in order to be a juror, you really only need to be 18 years old. And if in a general election, there'd be 170,000 people capable of voting, how come you only have 68,273 persons on the eligible jurors? This number was as a result of a jury revision exercise last done in 2009, sir. Under Section 9 of the Juries Act, the Registrar of the Supreme Court is to prepare and publish a list of persons in each magisterial district who are eligible to serve on the jury. Now, if you have, again, 250,000 people able to vote, how come you only have a jury roll with 63,000 people? So we have to come up with a different algorithm. Part of the reason for this, Mr. Speaker, is because, and it isn't something that we talk about often, our Juries Act still requires that before you can serve on a jury, you must be in possession of land. You must be a landowner, sir. In order to serve on the jury, you must be a landowner. Not that it has to be valued a lot. The site value just has to be at least $960. But the point is, sir, we removed a property requirement in order to vote. So why would there still be a property requirement in order to serve on the jury? So you must, this is exactly what it says. So you must be in possession of property with a site value of $960, or you must be an occupier of land with values under the Land Valuation Act of not less than $1,400, or you must have paid property taxes of not less than $960, or you must have clear income of not less than $1,400. These things are anachronistic. They've remained unchanged for 55 years, and quite simply, Mr. Speaker, they need to go. We're modifying the legislation. We are rooting out all the old systems. So now where you have court marshals have to go and serve jury summonses on individuals, we're just simply saying that they be served. So that leaves it open to the system to use registered posts and things of that sort. But perhaps the most important things, the most important changes in this Juries Act, and these are things that are, and again, we consulted, sir. And we had a very important consultation with the members of the criminal bench. And they're very keen to have this particular bill passed into law before the next, we know it's no longer assizes, but we still call it that, before the criminal year starts. We're having more and more complex cases, Mr. Speaker, and as you know, the time that is allowed for deliberation is 3 hours, but it can be extended on an application if the majority of the juries want it. But cases are becoming more and more complex. In a recent meeting, Mr. Speaker, I have been told by a judge that the average murder case will take between 5 and 6 weeks. Now, there are a number of reasons for that. Maybe they don't need to take 5 to 6 weeks, and we will come to those on another occasion. But the point is, when you have video evidence that they have to listen to, when you have medical reports, when you have a whole set of things that have to be taken into account by the juror, 3 hours is clearly not enough. But equally, Mr. Speaker, it is now happening frequently that you have cases with 5 and 6 and 7 and 8 and 9 accused. And the jurors have, I think you would agree, they have to consider the evidence in respect of each person. Now, if you have 6 accused and you can deliberate for 3 hours, you really have little time to focus in on accused 1, accused number 2, accused number 8, accused number 9. So the bench has recommended that we simply increase the deliberation of time to 5 hours in all instances. 5 hours. If you come back early, good. But if you go past 3, you don't need to come to ask the judge for anything because the time is now 5 hours. But by providing for 5 hours, it allows the more complex of cases to be deliberated on by the jury without having to feel that they are under any particular pressure. The other important amendment, Mr. Speaker, has to do with joinder of offenses. As you know, sir, the array that is required for a murder case is 12. Now, an individual, as has happened in Barbados, will often commit multiple offenses and end up with a murder. A person who shoots an individual is guilty of firearm offenses. If the person dies, he's guilty of a murder offense. But under the law as it stands, because you can now join firearm offenses. But let's say rape, for example. That's a better case. A person may rape and then murder. If the individual gets off the murder case, you couldn't join the offenses, you got to try the murder by itself, because there's a jury of 12. The person may get off the murder case, and you know got to come back and try to do a rape case. Same witnesses. Imagine the trauma that those witnesses have to go through again. The biting cross-examination, having to confront this painful set of facts. So what has been recommended is this, sir, that where you have offenses that are all part and parcel of a murder, you can join those offenses and do a single trial. The majority, the unanimity of the murder remains the same, but for the other offenses you can accept. You really only need to have a different majority, so it's not a unanimity situation. This, sir, is very important because and in fact, as I said, we've already done this with the Firearms Act because we recognize the importance of it, but we're now dealing with it in a more holistic manner. So we had a case where there was a vicious rape, sir, a person who had already been convicted of rape, kidnapped a woman, held her for days, raped her on multiple occasions, and then murdered her, sir. Murdered her. Now, had that individual, happily the person got convicted and they were given whole life. So there's less academic in this case. But in an instance where you were able to try the rape cases all at the same time because you could join them, the true impact of that person's offenses and the true sense of satisfaction that justice will have been achieved will have been met simply because you're able to join these cases together. So that is the other significant element of the amendment to the Juries Act. Not the amendment, sir, of the new Juries Act. This Juries Act gets rid of a lot of the anachronisms. Things like embracery, we've gotten rid of that old thing, and now we just talk about people who intimidate witnesses and so on. So we've tried to modernize it. We've kept a lot of what was there, because what was there was largely good. But all the old things, the anachronistic things, the useless things, have been removed, and we now have a new Juries Act that has satisfied certainly the bench in its ambit. I will say, sir, that the one matter that has to be addressed, and which I've begun to have discussion with the Minister of Finance on, the Minister in the Ministry of Finance on, is the matter of the amount of money that is paid to jurors. For donkey's years, that amount of money has been $10, sir. $10. Now, sir, when you look at the value of money, and you look at what $10 was in 1970, 1980, and 1990, and you convert it to a present day value, you would see while it is still small, it will still represent a change. And it is important, therefore, and when you think about bus fares, sir, a juror who has to catch a bus to town, they'll then walk to the court, but then they're gonna catch a bus and go back home. So the majority of the $10 gone in bus fare. And you can't feed yourself on $4 a day, because you're at court all day. $3 a day, sir. So we need to relook the amount of money that we pay jurors. This is not intended to be a salary. Everybody has to do their civic duty. But we do need to make sure that the fee is increased a little bit to make sure that people are not out of pocket when they serve in this way. Two last things I want to say in relation to jury, sir. We are going to be increasing the number of individuals who are selected for jury duty. What is happening now is that for some bizarre reason, people are doing jury duty 3 and 4 times. I'm wondering why. Are we calling up the same people all the time? One company, sir, one company wrote to me to complain because they almost, and I could see why they did, they almost felt like they were being unfair. In a particular period, and they checked it, a lot of their staff were called up for duty. Between the period January to April 2024, they had 7 persons on jury duty from their staff. And the average time that they spent on jury duty was between 34 and 67 days. 67 days is 2 months. Now, to have your staff out for 2 months is going to be a hardship. In 2023, they had 7 persons on jury duty. The longest person was on jury for 94 days, sir. 94 days. There's a hotel who reported on one occasion that on a particular shift, it could not feel anybody because everybody on that shift was on jury duty. These are obviously outliers. These are obviously exceptional circumstances. But the way to address this, Mr. Speaker, is to do what is within our power to do. Because we've gotten rid of the property requirements, the pool of eligible jurors is now to its real number. You are now dealing with a far larger number than 63,000 people. We are going to be selecting a larger number of individuals to serve jury duty so that we'll begin to eliminate this instance where people are doing jury duty on multiple occasions. So jury duty, sir, is important. We have a large number of people who every time they get called up for jury, oh, I want to be exempted, I want to be exempted, I can't do this, I can't do jury duty, who can do this, who can pick up the children, who can all. Everybody has every reason in the world not to do jury duty. Well, if nobody wants to do jury duty, then we can do judge-alone trials for everything. But unfortunately, judge-alone trials are by consent only. So an individual who says he wants a jury trial has to be able to get a jury trial. So we hope to be able to reduce instances of everybody trying to get out of jury duty simply by increasing the pool of individuals who we call up for jury duty. Mr. Speaker, I'm going to end just now. Let me just talk briefly about the final bill, which is to do with the Police Amendment Act. At the outset, Mr. Speaker, I want to thank the police service and the Barbados Defense Force for their hard work over the last number of weeks. We've just finished crop over. Our officers worked extremely long hours. They were deployed in large numbers, and it cannot have been easy for them or for their families. for many weeks now, they have had to give up one of their 2 days off. And we thank them for their sacrifice. We know that it will have been difficult for them, but the people of Barbados appreciate the fact that they've been able to see us through a Kaduma with virtually, with no major incidents. The job though is not finished because CARIFest is around the corner. And that is going to place some challenges on them as well. We've come to amend the Police Act, sir. The Police Act, again, another act that's been with us for a long time. We're doing a number of things. The first thing is in relation to special constables. Up until 2021, up until 2020, special constables were treated as casual workers. Now, we on this side all remember when former Prime Minister, the Right Honourable Oinafa, now deceased, got rid of the concept of casual workers in Barbados. But somehow, special constables, remained with that aura about them. And in 2020, so we came to government, said we were going to do various things, and the special constables review was one of them. And we therefore, by policy direction, directed that they were to be accorded the status of public officers so that they would receive pensions under the Pensions Act instead of receiving pensions under the Casual Employees Pensions Act. As special constables who were casual workers, they didn't receive a gratuity, sir. Didn't get a gratuity. But these special constables work every single day. They work right beside regular constables. In many respects, they do the same kinds of duties as the regular constables. And therefore, it is important for us to make proper statutory provision for what we've already done by policy. But you will recall, Mr. Speaker, that during the budgetary statement given in March of this year, the Minister in the Ministry of Finance announced that with effect from the financial year 2025-26, special constables who have served in that capacity for 3 years or more will be able to transition into police constables as of right, should they choose to. Mr. Speaker, we have 47 special constables and 46 have agreed to go over to the police service as constables. The only thing that has been standing in their way is this bill. And therefore, we come to Parliament today to change the legislation to allow for special constables to transition as of right into the police service. But the other thing that we're doing, sir, the other important thing that we're doing, and it may seem small, but you'll recall that during the Constitutional Amendment of 1921, when we moved to become a republic, we had to change the name of the Barbados Police Force to the name of Barbados Police Service. But the Act is replete with references to police force, so we had to make those changes throughout the bill. The other important thing that we're doing, so a lot of changes are consequential in relation to members of the service, now talking about service as opposed to members of the police force. But the other thing that is important, sir, has to do with qualifications to enlist. We changed the qualifications a few years ago to increase the age. But now we want to make an important change to the qualification requirement for enlistment. More and more, Mr. Speaker, we are seeing individuals who do not pursue normal courses of study, but who become so expert in what they do that they have skill sets that the police service of Barbados will need. There's a young man whose name I will not call, but he went to Combermere School, and he was wheelchair bound for all of his life. But he left Combermere School. I'm not priming the school pump, sir. I'm just saying, it's a fact. He left Combermere School, went on to work at KPMG. And up until his death, demonstrated such proficiency for his work that he was lauded throughout the length and breadth of Barbados in this field. But he was wheelchair bound, Mr. Speaker. He couldn't pass any physical. A former president of the Senate of this country was blind. Oh, she went to Combermere too?
That is correct.
Sorry.
That is correct, Honourable
Sorry,
Member.
Mr. Speaker, I didn't mean to do that. That was happenstance. Happenstance. But has an acumen, sir, that is second to none. But has skills that might be of value all over Barbados, all over the globe, but couldn't pass a physical. The Jamaica Constabulary indicated to me on a recent briefing I got from them in Jamaica that they are looking to recruit a young Jamaican citizen who has mobility challenge. In fact, they have no mobility from the waist down. But is the sharpest thing when it comes to digital forensics. Can't pass a physical. Now, when we were looking at making the amendments to change the physical requirements and to change the age, this discussion was beginning to happen. The height. All of these their limits are set. We've removed the height requirement from ours now. The shortest police officer in the world is 4'3". A woman in England. What is a police officer? What is a person's height or length or breadth or weight or any of those things really to do with their ability to contribute? Policing has now become so specialized, Mr. Speaker, that we need police officers who may end up having to know more about accounting than knowing about fingerprints and knowing about assault and rape and murder. Because things like money laundering, financial investigations, these are all things that are now part and parcel of the daily diet of our police service. So we had to decide, are we going to stay bound to 185 years of history where it was about brawn and muscle and build? Or are we going to recognize that we have individuals across this nation who may have specialized skills, but for one reason or another may not be able to satisfy the physical requirements or the other requirements that are set out in the relevant provision of the Police Act. And therefore, we have determined that at this juncture in our development, we want to be able to include all of our citizens as long as they are of good character and good report. So we are going to be introducing a new subsection, Intersection 24, which will say, notwithstanding to A, B, D, and E, the Commissioner may enlist a person into the service who possesses such special skills which are required by the service to enhance its operations. Special skills required to enhance its operations. The one thing that we're not allowing a derogation from is that you be of good character. That, before anything. But so long as you're of good character, we're saying that the police service is going to be able to, needs to be able to recruit you, even though you may not pass any of those other stipulated requirements. We think, sir, that the time has come for this novel approach, and I therefore commend that to this chamber. The other matter that we're addressing has to do with members of the Defense Force who are deployed under the usual arrangements to operate under the provisions of the Defense Act by the Governor General alongside the police. We saw them on Spring Garden, on the roads, on Kadooment Day, and they did a fine job supporting the work of the police. They've always done a fine job supporting the work of the police. But what is not realized, sir, is that those BDF officers who are deployed under the Defense Act to work with the police service do not have any powers of arrest any greater than any of us in here. Any greater, he has the same power of arrest as the snow cone vendor, as the shopkeeper, as the taxi driver. Everybody has a common law power of arrest. Everybody also has a power of arrest set out in statute. But it is a very simple and basic power of arrest and does not accord you any privileges and immunities. So perhaps sometimes when you see on video BDF officers standing up alongside police, members of the police service, and you wonder why they don't get into the fray, it is because they have no power of arrest. So what we're doing, sir, in order to be able to really make that work effective and the support of the BDF, support by the BDF for the police service while they're doing their patrolling and so on, to make that meaningful and active, we're proposing to amend the Police Act to provide that while, let's understand this clearly, while patrolling, while on duty with the police service, you have the power of arrest that a policeman has, or policewoman, and you also have the same privileges and immunities. Now, when you go off duty, you can't arrest somebody, because these only exist while you are on deployment. So you don't have this power outside of that. But as long as you're on deployment, you have the same powers of arrest as a police officer. And more important, or equally important, you have the same privileges and immunities. And this is an important initiative in our view to be able to help the police service to benefit in a greater way from the support of the BDF as they do the joint deployments. Mr. Speaker, Barbados is still a safe country. It is safe because of the hard work of the police service, because of the hard work of the BDF, all the law enforcement agencies. It is safe because, Mr. Speaker, in our own way, every Barbadian helps to carry that weight. Every Barbadian helps to make us safe. But the duty of the state has always been the responsibility of law enforcement, the responsibility largely for the prevention of crime through various interventions, and the responsibility of making sure that our criminal justice system works. We have checked many of the boxes under the Needham's Point Declaration. Our forensics laboratory is expected to be up and running in September after not being functioning for almost 15 years, sir. It was functioning when we were in government, but we left government, and then the forensics center seemed to crash. And we've been struggling to bring it back up, sir. And I'm happy to report to this chamber that our forensics laboratory will be up and running before the end of September. We have a better equipped police service than we've ever had at any time in our history, with a larger budget than they've had at any time in their history. We've put all those tools in place. We've put funding in a crime prevention program to be able to say it isn't always about licking and lock up. Without social intervention, you will just be in a reactive position all of the time, sir. The countries in the world that have the largest number of people in prisons still have the highest murder rate, still have the greatest degree of people, the greatest number of people on drugs, still have the greatest societal challenges. So we must not fool ourselves into thinking that we can strong arm ourselves out of a difficult situation with crime. Locking up, interdicting, charging, prosecuting, all of these things have its place in the criminal justice system, but that is not all, and this administration recognized it long ago. When we first came to government, we were then and still are concerned about what was happening in our country in relation to crime. We offered a briefing to all the parliamentarians, a security briefing. All of the senators, including the independent and opposition senators. We gave a high-level briefing to the leader of the opposition. And then we went on to give a high-level briefing to all of the senior public servants and heads of departments so that they could understand that it's not just about what we do in this room as cabinet. It's not just about what happens in this room as parliamentarians or in the other place as senators. It is about government using all of the tools in its arsenal to help to improve our society and cut down on crime. We've continued on that mission, Mr. Speaker, and I'm satisfied that notwithstanding what is happening today, notwithstanding that we have a spurt in homicide cases, I'm satisfied that we have what it takes to deal with it. We have to congratulate the police, Mr. Speaker. Every day, they're making significant arrests. Every day. They don't blow their own trumpet, and perhaps that is something that we need to change. Because in the United States, you know, you would see the mayor, the deputy mayor, you would see about 20 people. There's only 2 police that lock them up, you know. But you see 20 people and everybody pushed up the chest with the uniforms, you know, going to the press saying, oh, this is what we've done. Our police have tended to be very reticent. They have not been vocal. And that is, we're trying to get them to talk a little bit more. And believe me, sir, they are talking a little bit more to the public now than ever before. Because an informed public has a better understanding of what's going on. They have a better understanding of the challenges that we face. And therefore, they have a better understanding of the role that they can play in supporting our efforts. We've put money in crime prevention. We continue to put money in crime prevention. We put money in the social services. We've put money in the One Family program. All of these programs to try to help to pull people out of that situation. So that is what a government does when it is tough on crime. Because you see, being tough on crime is not just about charging people. It is also removing the oxygen. It is removing those young people who become the fodder for the drug dons. It is about keeping them out. It's about saying, leave them little children alone. They are not following you into perdition. Because that is being tough on crime too, sir. Trying to starve it of young recruits. And we've been successful. And we continue to work hard to be successful. I asked this chamber to support these 5 pieces of legislation. There are going to be more to come. None of them singularly will solve our problem. None of them, not one of them will solve our problem. But together we strengthen the hand of the people who are on the front line and who are the ones who need to carry the fight and who are carrying the fight on behalf of the people of Barbados. I thank you all for your patience. I thank the police service. I thank all of law enforcement for their hard work. We're going to lean on you some more, but for the greater good of the country, and the Barbados Police Service knows it has always had the support of the Barbados Labour Party when it is in government. Mr. Speaker, I'm obliged to you. Well, now or after? 2:15? Quarter past. Mr. Speaker, I beg to move that the chamber now adjourn, suspend, for 90 minutes.
Could you, Honourable Member, could you qualify that into time?
9:06,
Could you-
2:20. You want 2:20, 2:20.
The question is that this honorable chairman will be suspended until 2:20 p.m. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it. This honorable chairman stands suspended until 2:20 p.m.